Good morning, ladies and gentlemen, and welcome to another episode of PLA with myself, Nick and Bruno. We've got a couple of questions with us today, and we're going to be jumping straight into them. The first question, Nick, comes from a managing agent, and the question goes as follows. I have a tenant that moved out of a property at the end of last month, and we obtained 3 quotes from different contractors to fix a couple of issues in the apartment that the tenant was obviously staying in. So the landlord has sent them a message stating that the agent, should use the entire deposit to cover all the repairs and let him know of the outcome, right? It seems as if he is placing the responsibility of finalizing the matter on myself as the agent and the tenant to resolve. So it seems as if the actual landlord here, Nick, is distancing himself from the exit inspection and how the repairs are going to be done and etc. And so the question then from the agent becomes, how can we handle this diplomatically? This is a managed lease, and in the light of the fact that the tenant has already moved out, and we need to refund the tenant's deposit.
Okay, so it's interesting because look, the couple of elements here. The first thing is there doesn't seem to be a problem with regards to the actual reinstatement of the premises. So the tenant's moved out. There needs to be some sort of refund of the deposit, provided, of course, there's not damage to the premises. If there's damage to the premises, the tenant can be liable for it. And the deposit is the asset which is kept by the landlord in order to address those problems. The landlord in the circumstances has gone and he has got 3 different quotes, for the repairs on the premises. So from that perspective, this sounds like the landlord's doing everything correct. Okay. The question then comes, we don't know the extent of the damages or whatever the case is, but the landlord having, got 3 quotes, I doubt very much this is a circumstance where, one quote is very little and the other one is the most expensive one, and the landlord's just trying to use up the deposit. There'd really be no need for the landlord to do that in circumstances. And in any event, the landlord is entitled to elect who they want to remedy the property in the circumstances. So there seems to be a suggestion that the entire deposit is going to be used. I'm assuming that the quotations for the repair of the property exceed the value that is held in the deposit, in which circumstance the landlord is perfectly entitled to use the entire deposit. Okay. If there are damages on a property to the value of 10,000 Rand and you only have a 5,000 Rand deposit, the landlord is entitled to use the entire 5,000 Rand and nothing would be refundable to the tenant. That's absolutely legal. That is the way it works. And ultimately, if that is the circumstance, the landlord still has a claim for the balance against the tenant in the circumstances. So there doesn't seem to be any problem there. That all seems very fine. Okay, just because a deposit needs to be refunded doesn't mean that it has to be. Okay, I don't know if there's a worry there. The other second part of the question really is the agent saying, well, the landlord is expecting us now to engage with the tenant and sort out this problem. And there doesn't seem to be anything that's really a problem there either. The writer makes the comment at the end, this is a managed lease agreement. Okay, so if it is a managed lease agreement, it's not something like a procurement mandate where the only expectation of the agent was to procure the tenants and then walk away from the circumstance that the landlord's going to handle all of the obligations thereafter. If it was a procurement mandate, then I agree that the agent in the circumstances could say, well, look, that's not what my mandate says. I was supposed to get you a tenant and then I walk away from the circumstances. In this particular circumstance, it looks like, because they say it's a management mandate, this probably does fall within the realm of obligations that you have in respect to the particular lease agreement. You need to deal with the tenant relations. So really, it doesn't seem like there's a problem here that would be expected as the agent to handle something like this, unless there is, for some reason, you've got a very specific mandate which says I only deal with rental collections and everything else is the landlord's responsibility. And then the question is going to come down to, well, what are the specific terms of the mandate? So you hope that you have a written agreement in the circumstances. It says, I only do ABC and I don't do DEF. In those circumstances, look at your mandate, find out where your specific parameters are, But otherwise, I mean, it does seem like a perfectly valid circumstance. You've got a handle, and I don't see anything wrong with the use of the deposit in the circumstances. Everything seems above board. So you simply let the tenant know. Unfortunately, there are damages on the property, and your deposit is going to be used in full towards the damages on the property.
Absolutely. So yeah, thank you very much, Nick. It seems to be straightforward there, and if there are any further challenges, then they can contact us, and we would gladly answer further questions or see if we can actually come on board to us.